Have you had enough time to discuss this decision with your attorneys?
Yes, Your Honor.
And is it your decision alone not to testify?
Yeah, I'm not going to testify, Your
Oh,
Honor.
all right, then I will instruct the jury according to the law which I just read to you. All right.
Yes, Your Honor.
So there you have it. Kellen Winslow II, that's the big news today, decided not to testify. So what was in the defense case? They had 5 witnesses. There was testimony that added up to about 85 minutes worth of evidence for the defense. 85 minutes of testimony, we calculated it. All that took place. He decided not to testify, and then this happened.
Any additional witnesses?
The defense rests, Your Honor.
All right, you want to offer 183?
Yes. Yes, Your Honor.
Any objection?
No.
Okay, 183 will be received and the defense rests, correct?
Correct. Yes, Your Honor.
And the defense rested. So you had 5 Jane Does that testified for the prosecution, plus all their other witnesses, about 29 total. 5 for the defense, very quickly on and off the witness stand. And now this is closing argument eve on closing arguments. Let me go back out to San Diego. Vic Bajaj is with us, great criminal defense attorney out there. I'm asking a lot of the local attorneys about this, the pacing of this case. I don't know if years ago there was another football player who was on trial in California and it took like 9 months and there was the charge of murder. This one, 5 different accusers and things moved very quickly over the course of 2 weeks. Should we be surprised at the pacing of this trial?
It really depends on what's behind door number 2. Is there other forensic evidence out there? Are there other things that need to be tested? You can open up, go on Google, and you'll see that locally here there's an extraordinarily long backlog of DNA testing that needs to be completed here in San Diego for rape victims, sexual assault victims, and domestic violence victims. Now, the district attorney's office is going through their paces to make sure that catches up, but we don't know what else was out there. And this also dovetails into other witnesses, such as Mr. Vaughn that we talked about a bit earlier. We don't know what's behind door number 2. But let me just comment on the pace of this case in general, notwithstanding an exigent circumstance with DNA or forensic evidence and trying to avoid that from rearing its ugly head. This case has moved quickly. And I'll tell you, I try cases in this jurisdiction all the time. And this has just moved so fast. We're at barely about a year, I'd say, or around a year since the first arrest took place. You would expect that the investigation, both on the district attorney's side and the defense side, would have been a bit more well-developed, in my opinion.
All right, Lieutenant Colonel, what do you think about the investigation here and the pacing of it? I mean, very quickly from the beginning of Jane Doe number 1 to the trial.
I think it was rushed. There was really no sense of urgency to get a trial over with. You know, all the players are there. You have time on your side. So I think they should have taken their time. Certainly the prosecutor should have taken more time. And in the case of Mr. Vaughn, that should have been developed and ironed out way before they decided to start the trial. They should have had Mr. Vaughn in place, at least for a statement or something.
To figure out what may have happened there. Rachel, who gets the advantage now in this quick trial, quick to trial, and then the trial itself moving very quickly?
I hate to say this, but I think that the prosecutor sadly gets the advantage here. Again, it's easier to connect the dots when there's fewer dots to connect. Look at all these victims. They're not putting up extraneous random stuff to confuse the jury, and they're just saying, how could, basically, how could this be if he wasn't guilty? And so I think in making it quick, I'm sure it didn't feel very quick to the jury that sat there every day.
Right, they have no perspective. It's the only trial that they're probably sitting on. You know, someone else testified for the defense. Jane Doe number 1's daughter. If you recall, she was originally a witness for the prosecution. She was watching the trial on court TV, heard her mother testify, didn't know anything about the trial was taking place, calls the DA, ends up on the witness stand to corroborate some of her mom's testimony, and then comes on court TV and had already started a GoFundMe page. So the defense decided to call her back to the stand to try to attack her credibility. Take a look.
Is that you and your mother's GoFundMe page?
Objection compound.
It's my GoFundMe page.
The objection's overruled based on the answer.
On behalf of your mother?
Yes.
How much money were you seeking to get?
$50,000.
Did you feel like, as you testified before, moving out of state may be a good idea?
Yes.
Now, the fact that you included the request for $50,000, where does that amount come from?
I was thinking about therapy cost, moving cost. Pretty much I was thinking, so the average wage of someone is like $50,000 in a year. So I was thinking to make sure that she is covered for at least a year while she settles and finds a job in the new state. I wanted to make sure she'd be covered.
All right, so $50,000 GoFundMe page. The page, I believe, was taken down. She didn't get any money out of it, but that doesn't, I don't know. Ray, does this change the game at all? Does this now make the jury say, Jane Doe number one, we don't believe you?
Well, I don't think so. I think that she responded to that question about what was the money for, I thought, very well. Of course, we're not in the courtroom, so we don't see all of her body language and facial expressions. It does, however, allow the defense, if they want to get into a money grab argument in closing, to at least have one piece of evidence so that they could say, well, you know, when the state starts screaming, objection, objection, judge, she could say, well, Your Honor, you know, the young lady said that's a money grab. It doesn't have to be for all of the witnesses. So at least allows them to inject that. And you saw that that was part of the defendant's media presentation. He said it many times. It's just a money grab. It's just a money grab. So that may be in the jurors' back of their mind as well.
I think that'd be more convincing had Jane Doe actually been the one to do it. The fact that the daughter saw court TV and then decided, maybe I can get.
Well, no, she actually posted before she was ever on court TV.
Oh, okay,
She testified that she posted the page once she knew she was going to testify after she had spoken to the DA. Does that change
No, that's
your
even
answer?
stranger.
Yeah, I just don't think it has any evidentiary value. It allows the defense to maybe even get a charge that may say, and you can look at witnesses' financial incentives or motivations, witness or witnesses, and then try to spread it across all of the witnesses, which I think is not a great argument. But listen, when you're defending a case like this,
You gotta
and your
throw
client
everything out
doesn't
there,
take
but
the
it-
stand,
at the
you
end
got to
of
put some stuff up there.
At the end of the day, this is all about credibility now. You have victims that that may not be that credible. You have a superstar athlete who's from a lineage, you know, of superstar. His father was an athlete, Hall of Famer, and so that it's he said, she said. You have to look at that, and pretty much credibility is all the jury has to depend on. Is do we believe these people who two of them are homeless, one of them came forward
16 years later.
16 years later. You have these other people, this other lady at the gym, you know, so there's no hardcore evidence except for that DNA from Jane Doe number one. That's it.
Yeah, it's not a case with a lot of physical evidence, so we're going to talk more about that coming up in a little bit. You know, today's big story, if you're just joining us, Kellen Winslow II did not testify. It was a big moment inside the courtroom. Now, the jury didn't see it, but they've been instructed that they cannot use that against him. But I want to know what you think about all of that. It's our 13th juror question tonight.